5 minutes, 5 past. I think we'll make a start, shall we? Okay, welcome to the latest in the Aspire Barristers series of webinars. They can all be found on YouTube. You just have to search for Aspire Barristers, and in due course, this webinar will be uploaded too. Today's topic is in financial remedies on divorce and dissolution of civil partnerships. The title is The Size of the Pot, as in matrimonial pot, Fringe Assets, the Tricky Cases. Let me begin with a spoiler alert and safety warning. I've made the assumption that no attendee is likely to be operating heavy machinery in the near future, but hopefully this talk will not be too soporific for your biorhythms. Actually, I'm kidding. This stuff is really interesting, assuming you are a financial remedies nerd. If a question occurs to you during the talk, click on the chat icon at the top of your Zoom screen, type it in, and perhaps we can get to those at the very end of the talk. Okay. So we start, as always, with the statute. When deciding whether to grant a financial remedy, Section 25, subsection 2, paragraph A of the Matrimonial Causes Act requires the court to have regard to income and incapacity property and other financial resources which each of the parties to the marriage has or is likely to have in the foreseeable future. In this talk, I intend to deal just with those 3 words that I've underlined and talk about those and the effect and the cases that involve those words. And when saying other financial resources, I think the stress or emphasis is on the word other. This refers to the situation where the property in question does not belong to either party. If it did, the words would be redundant. Nevertheless, one party has or is alleged to have some sort of access to it. It is property belonging to or controlled by a third party, so we may refer to it as third-party financial resources, and that is what we will be considering. It was made clear by the Supreme Court in Prest against Petrodel, lest we were blissfully unaware, that property in that subsection means a proprietary right, legal or equitable, in possession or in reversion. Rather to the same effect, 2 years earlier, in a case called Whaley, Mr. Justice Lewison, as he then was, quoted that section and added, before considering how to exercise, before considering how to exercise its powers, the court must identify what are the property and other financial resources in relation to which its orders can be made. Property is property. Its nature and extent do not differ according to the division of the High Court in which the proceedings are heard. Financial resources is a more flexible concept, but even then it is necessary to consider the legal structure of those resources and the mechanisms by which such financial resources can be made available to one or other party before considering the likelihood of that happening. We shall return to that point later. Perhaps the most transparent form of third-party resources is that covered by Section 24(1)(c) of the Act, namely an ante or post-nuptial settlement, which one may attempt to vary or resist varying, as the case may be, for the benefit of the other spouse and or the children. The live question here is often whether the settlement can be classed as nuptial or not. However, that is a niche talk in itself. It's not my focus, and I'm not going to deal with it today. Instead, I'm going to deal with 4 different situations or categories, which we can whiz through. The first case is where a non-spouse or third party is alleged to hold an asset on behalf of a spouse. So as a matter of law, we call the third party a trustee. And that assertion is disputed by the spouse and the third party. I'll call this category 1. The second case is where a spouse alleges that an asset in his name is in fact held by him on trust for a third party who asserts beneficial ownership. That is the reverse of situation 1, so can be referred to as category 2, no surprises. The third situation is where a spouse is a beneficiary under a discretionary trust. The existence of the trust is never in dispute, but access to the resource is, because the only entitlement of the spouse to be considered by the trustees for appointment of capital or income, is to be considered for appointment of capital or income. So we can call that category 3. And finally, the fourth situation, the bottom of the slide, is where the spouse has no interest in the resources of a third party, but it is alleged there is a likelihood of benevolence in favour of the spouse, or perhaps restitution where there was a previous gift to the third party by that spouse. So I'll deal with these 4 categories in turn. But we are not here concerned with the rather different situation where a spouse has in fact divested himself of an asset to a third party so as to defeat or reduce the claim. That, of course, can be reversed under Section 37 of the Act. Rather, the spectrum of situations we are looking at today includes cases where any supposed transfer to a third party is said to be bogus, it being alleged that the spouse retains his interest despite appearances. However, in such a situation, one could allege in the alternative that if the transfer is not bogus, then it constitutes a Section 37 disposal. That need involve no contradiction. See, for example, the case of ND versus SD, where the wife relied on Section 37 as a fallback position, as a hedge to her primary case that the trust was a sham entity. As it happens, on the facts, both contentions failed, but the wife partly succeeded on other grounds. Now, the reason it is important to keep in mind these separate subcategories of third-party resource is that otherwise one risks running a case that is internally inconsistent. It's always possible to run stacked alternative allegations. The danger is advancing one case weakens the other. That happened in A versus A, where the wife it was who alleged that 2 trusts that owned a majority shareholding in the family business were both shams, but alternatively, that the trustees of those sham trusts could be expected to do exactly as the husband bidded them to do. Well, that must have seemed a sensible strategy at the outset, but Mr. Justice Mumby, as he then was, made the rather unflattering observation that Wife's counsel is, of course, entitled to put his case in this way, but it must be appreciated that the two cases he seeks to make are quite inconsistent with each other. The first proceeds explicitly on the basis that the trusts are both shams. The second proceeds on the basis that the trusts are not shams. In other words, they are genuine. Ouch. This illustrates, I think, an important point when alleging third-party assistance or benevolence, or what I've referred to as category 4 above, as a fallback position, because it can make the main argument, your primary case, for example, a category 1 case, seem feeble. It's as though admitting that your primary case really has no legs and you have no confidence in it. Instead, an early analysis of strategy is essential to prevent your case avoidably unraveling later, or leading to the criticism that you or your client has changed horses midstream, and consequently the assertion that your new case lacks forensic integrity. Now, avoiding that state of affairs is the purpose of this talk. So let's talk a little bit more about categories 1 and 2, a bit more detail. You'll recall that category 1, this is where a third party is alleged by the applicant to hold an asset on behalf of the respondent spouse, but that is disputed by the respondent of the third party. And category 2 is where a respondent alleges that an asset in his name is in fact held by him on behalf of a third party, and the third party asserts beneficial ownership, which is the reverse of category 1. These two mirror image situations can be analysed together. As Lord Denning pointed out, as long ago as 1980 in Tebbers and Haynes, such ownership disputes are determined just as if the matter was litigated in the Chancery Division. Property is property, no matter which division of the High Court you are in. One point to note, which is not intuitive: where an alleged trust is an express trust in writing, the challenge to it is that it is a so-called sham trust. These are quite rare beasts. To be a sham trust requires proof that all parties to the transaction were acting in concert, such that the trust documents were false at the time they were executed. If you look up the case of ND and SD, Mrs. Justice Roberts gives a very useful analysis of the jurisprudence of sham transactions at paragraphs 176 to 190. If you ever have such a case, I strongly recommend you read that page before going any further, because basically it gives you a template of what you have to prove or disprove, as the case may be. Well, that's an oddity, though, because far more often an alleged trust, in other words, the beneficial interest, is held other than by the legal or paper owner, is implied from intention, presence, or lack of donative intent. The procedure to be followed to establish the beneficial interest of the spouse, and thus the ownership rights of the third party, was fleshed out by Mr. Justice Mostyn as Nicholas Mostyn QC in TLVML 2005. This will be familiar, so I summarise briefly. First, consider whether there should be joinder of the third party, Rule 926, the grounds being that there is an issue involving the new party and the existing party, and an existing party, which is connected to the matters in dispute, and it is desirable to add the new party so that the court can resolve that issue. Then each party's case must be pleaded, points of claim, points of defence, and then separate witness statements directed, and the issue set down as a preliminary issue prior to the FDR. The burden of proof lies on the party who is claiming that true beneficial ownership differs from legal ownership. In the case of Fisher Meredith is authority for that proposition with, as I say, echoes of Stack and Downton. Equity. Equity follows the law. It follows from this that if your client bears the burden of proof, you must seek to join the third party. If it is your opponent's client who bears the burden, you can wait to see if your opponent is awake. Fisher Meredith states you are not obliged to do anything in those circumstances. As an aside, in third-party resource cases, it may sometimes seem tempting, in the interests of proportionality even, and saving costs, to put off these expensive steps until after the FDR in the hope of negotiating settlement, perhaps with the third party, not yet joined into the proceedings, invited to attend the court building on the day and at the time of the FDR, either with or without legal representation, depending on the circumstances. This may indeed be sensible where the asset in dispute represents only a small proportion of the total matrimonial pot. But do be aware this is a strategy that has risks attached. Unless the court at the first appointment recognized that this would be an appropriate way to proceed, I would suggest in a recital to the order, thus postponing consideration of joinder of the third party. A district judge at the FDR would be perfectly entitled to refuse to give an indication on likely outcome before resolution of the third party resource issue, leading to the aborting and adjournment of the FDR and the belated implementation of the TLV-ML procedure. So trying to fudge the third-party issue, hoping the DJ will not get hung up on the distinction between a proprietary interest and encouraging financial assistance from the third party, can prove very expensive with hindsight. When the court resolves a dispute, either by agreement or at the preliminary issue, as to beneficial ownership, it will make a declaration, and if it's considered desirable, can order the sale of the property. Hang on. Okay. Or order a sale of the property under Section 24A6. And of course, the third party must first have the opportunity to make representations, which the court must consider. And it goes without saying that a property adjustment order cannot be made over that which the court has just determined to be the third party's interest, at the risk of stating the blindingly obvious. Category 3, you may remember my classification where category 3 is the standard discretionary trust. And let's say the respondent is in the class of beneficiaries under that discretionary trust. The only legal entitlement of a discretionary beneficiary is to ask the trustees to be considered for appointment of capital or income. The fourth and final category of third-party resources, you will remember, is the likelihood of being gifted money or property. This is obviously where the respondent has no interest in the resources of the third party, but it is said there is a likelihood of benevolence in favour of the respondent, and that's usually based on a history of previous gifts by that third party. Incidentally, as an editorial observation, these four categories are my categorization. They're not judicially approved, at least not yet. So unlike categories 1 and 2, logically, categories 3 and 4, these subcategories, are quite separate and distinct. In situation 3, the discretionary trust case, the expectant spouse has a real interest in the resources, albeit contingent on the decision of a trustee. Whereas in situation 4, there is no such interest, merely a space, a hope. Nevertheless, in my experience, tribunals can sometimes appear to elide the differences, thereby risking applying the wrong test. And factually, if not doctrinally, the two can appear to overlap like a Venn diagram, as I will explore. In category 3, discretionary trust cases, the so-called shaman question has to be asked and answered by the findings of the court. This phrase was coined by Justice Mostyn in Villiers at paragraph 105, seeking to apply shaman number 4. So the shaman question is, if the respondent as discretionary beneficiary were to request the trustee to advance the whole or part of the trust capital, would the trustee, having been appraised of all the relevant facts, be likely to make funds available to the spouse so as to enable enhanced provision to be made for the applicant? If the answer to that binary question on the evidence is yes, then the court regards that capital as the property of the spouse. If the answer is no, then there is precious little the court can do about it. That was the expression that was used by Mostyn in TL v. ML. When answering the shaman question, the court is not expected to determine what will happen in the future. It is merely required to assess the likelihood of funds being made available. So much is obvious, you may have thought, and certainly in other legal specialisms, that might be regarded as self-evident. For example, Lord Reed stated in Davies and Taylor, famously, you can prove that a past event happened, but you cannot prove that a future event will happen. And I do not think the law is so foolish as to suppose that you can. All you can do is evaluate the chance. At appellate level, two cases in particular have discussed the evidential factors at play. In the case of shaman itself, the appeal by the husband against the finding that the trustee would do as the husband asked was given short shrift. The husband relied heavily on the absence of any previous income or capital appointments in favor of in his favor from the discretionary trust. But the court held this was of no significance because the husband simply had no need to request access to such funds in the years in question. In stark contrast to his then current position, when suddenly he had to put his hands sharpish on £40 million lump sum, at the time, the largest lump sum ever reported, and where his letter of wishes to the trustees when setting up the trust insisted that the trustees should consider him the primary beneficiary during his lifetime. That wasn't a very promising appeal. Does it make a difference if the respondent was the settler, as in shaman? In Whaley, the Court of Appeal was fairly damning of the suggestion that there should necessarily be a distinction drawn on the likely attitude of trustees between, on the one hand, cases where the source of the trust fund came from the spouse, so-called settlor beneficiary, as in shaman, and where the source was inheritance, a so-called dynastic trust, as was the case in Whaley. It's worth reading what Lady Justice Black, as she then was, had to say. In advancing his arguments, counsel referred to the Farrer Trust as a dynastic trust. I use that term in this judgment only because he did, and certainly not intending to give the impression that I endorse it as some sort of technical term, still less some sort of ancillary relief concept with its own body of attendant principles. Individual trusts vary considerably, and global labels for them may be unhelpful as they risk deflecting attention from the particular terms of the trust under consideration. Having said that, I understand that counsel sought by means of the label to draw attention to the fact that the trust was not one set up or contributed to during the marriage by one of the spouses, but an arrangement set up by the husband's father before the relationship between the husband and wife even began, with the design of benefiting his sons and potentially succeeding generations. Now, the source of the funds, and therefore whether they are or were in a sense matrimonial property, is of course relevant to the overall discretionary Section 25 outcome. And Lady Justice Black was not questioning that, but that is completely immaterial to the Sharman question with which she was concerned. However, seems to me a court in practice, the district judge, is likely to treat a trustee's refusal to a request by a settlor beneficiary with caution or frank disbelief, unless it is plausibly explained. So what is the approach to the Sharman question? It seems to me to be as follows. Hang on. First, consider the legal structure of the third-party resources and the mechanisms by which such financial resources can be made available to one or other party before considering the likelihood of that happening. Mr. Justice Lewison in Whaley said as much. Remember that a discretionary beneficiary has no proprietary interest in the trust fund. He has a right to compel the due administration of the trust, which means he is entitled to compel the trustees to consider exercising their discretion in his favour, and he can also complain if the trustees exercise their discretion capriciously. There is no substitute for a detailed consideration of the trust deeds and any letter of wishes from the settlor. When determining the likelihood of resources from the trust being made available, it is crucial to have in mind these trustees' actual powers and restrictions on those powers. In this context, do not overlook that in deciding whether to exercise their powers, trustees may and should take into account the wishes of the beneficiaries and their needs, as it says in all the books on trusts. Next, what is the history of past appointments of capital or income? Because after all, recent history is often the best guide to the foreseeable future. If you want a case that actually says as much in this context, look no further than SR v. CR in support of that truism. A final order that is predicated on the trustees making provision for the paying spouse so that he or she is able without hardship to satisfy the order will not constitute improper pressure on the trustee if the interests of other beneficiaries would not be appreciably damaged. And it is reasonable, it goes without saying, and it is reasonable for the paying spouse to ask the trust to release capital to enable proper provision to be made for the other party. Last, has the spouse beneficiary already made a request to the trustees? And if so, what was the response? If the response was negative, is that to be believed? Or is it purposive and likely to be reversed after the case is concluded? Goes without saying that's case specific. But to illustrate the point, in Whaley, the judge at first instance, Mr. Justice Barron, found that the lead trustee had given false information to the court, cobbled together figures, and was unwilling, amusingly, to give evidence to be cross-examined on his support, on his professed attitude. The judge therefore felt entitled to disbelieve the trustee's answer. Incidentally, she also found that the husband had tried to conceal the truth behind his trust holdings and the use he had made of the funds over the years. Game, set and match. So we turn now from category 3 cases to what I'm calling category 4. The question here is different. To what extent can the court assume that any past gift or pattern of gifts will be repeated in the near future? There's clearly a difference, because in the case of a trust, the very reason for its existence is to provide benefit for the beneficiaries, whereas under category 4, unlike a trustee, a non-obligated outside donor can reasonably or unreasonably not come to the aid of the party that must pay the lump sum. So, should the court formulate an order designed to encourage the third party to make such a gift to the spouse, and which relies on that happening in the foreseeable future, for such an order to be fair, and sometimes for compliance with it even to be possible? Modern authority begins with the well-known case of Thomas and Thomas. A lot of articles have been written over the years on this seminal case. Such articles refer to Thomas cases, subdividing them into different types and so on and so forth. I detect that fashion has passed. So what does Thomas actually say, and how should one apply it in 2023? The case itself concerned neither a trust nor bounty from a generous, wealthy, close relative. Instead, it concerned a family business in which the husband, his mother, and brother were the shareholders. At first instance, an award of maintenance was made that would have consumed all of the husband's disclosed income from the business. And it was justified on the basis that he would be able to procure a change in the dividend, salary, or remuneration structure to increase his remuneration, notwithstanding that this would require the agreement of the mother and brother. The Court of Appeal upheld that approach. Lord Justice Glidewell, in relation to these facts, said, "I would apply the principles applicable to a request to a trustee to the family company as if it were a trust, and the shareholders, the husband, his mother and brother, were the trustees." Lord Justice Waite went further. There will be occasions, he said, when it becomes permissible for a judge deliberately to frame his orders in a form which affords judicious encouragement to third parties to provide the maintaining spouse with the means to comply with the court's view of the justice of the case. Well, this, it must be remembered, is obiter. It may go too far. There's a very powerful passage from the Chief Justice of Hong Kong in a case cited by Mostyn in Villiers in his judgment, inserted at paragraph 106. And the gist of that, the gist of that is that English courts, since Thomas, have consistently approached the question of third-party financial assistance by concentrating on the necessity to find, on the evidence, not only that third parties have previously provided financial assistance to husband or wife, but it was likely that this would continue in the foreseeable future. And the use of the phrase judicious encouragement should not be used, in effect. it's a red herring and obiter. So all of you who have cited that case, beware that that will come back to bite you. So the template for running a historic benevolence case is to first ascertain the level of past assistance. Second, seek a finding that it is likely that this will continue, all fact sensitive. Third, factor that into the respondent's resources so as to, demonstrate that the applicant's needs can be provided for at a level beyond that which would be fair, having regard only to what is in the actual pot. If the benevolence takes the form of income support, at an interim maintenance hearing, of course, the evidence will be much less developed. We don't know what the third party is likely to say if pressed. And there is a dictum in TL versus ML where Mostyn J says, where the paying party has historically been supported through the bounty of an outsider, and where the paying party is asserting that the bounty has been curtailed, but where the position of the outside provider is ambiguous or unclear, then the court is justified in assuming that the third party will continue to supply the bounty, at least until final hearing. That's paragraph 124 sub 5, characteristically Mostyn-esque, if I can use such an expression, pulling no punches. What about category 4 in practice? Well, historic benevolence as a basis for going beyond a fair share of the pot is highly vulnerable. However the law dresses it up, past generosity may seem beside the point when the true purpose of any further generosity is to benefit a now disfavored ex-spouse rather than the favored son, daughter, niece, or nephew. If a wealthy past benefactor relative says, no, not a penny more, as was the case in Luckwell versus Limata, and that evidence is not obviously untruthful, then the case will have gone to a final hearing when it should have settled at FDR or earlier. And the question will doubtless loom whether under 28.37 costs orders, whether it was reasonable to pursue the allegation where one knew the stance of the benefactor or third party at the latest at the FDR. That benefactor will have been joined, if not joined, will presumably have given a statement. And if he or she has said, that's it, no more, and has given a reason, well, that looks as though the judge is going to accept that unless you have something up your sleeve. Good luck with that. So cases where one relies on what we can call fresh money being gifted, where that has been expressly rejected by the benefactor, by the third party, are almost always going to fail. You might run the case to FDR, but it's very high risk thereafter. Cases that have better prospects are those where the open proposal is instead framed as a division of the actual assets shown on the Form E2 schedule that will only be unfair, only turn out to be unfair to the respondent if the benevolent third party does not afterwards make good, as it were, the loss to the spouse. These are sometimes referred to as backfill cases. That is, the award gives an applicant most of the assets on a needs basis, leaving it up to the third party after the case concludes to remedy the situation by providing resources or backfilling to the respondent. This also avoids any impossibility of enforcement issue, namely the argument that the court should not make an order that cannot be enforced. Why? Because it brings the law into disrepute. So finally, in the aftermath of separation, the parties often cannot wait for wheels of justice that grind so slow, and therefore sums are not infrequently advanced by the third party, often but not always the bank of mum and dad, to pay for legal costs, house deposit, car replacement, etc., etc. We are used to it being protested that these sums are strictly to be repaid and should not form part of the pot, i.e., the debt should be deducted when computing the net assets of that spouse on the Schedule of Assets ES2. Sometimes a written loan agreement has been prepared to emphasize the obligation to repay, and the third-party lender may even be prepared to give evidence to that effect. Here, the question of whether this was a soft loan is exactly the same issue as in a Category 4 case, if you think about it. It's a distinction between future gifts, Category 4, and past gift, soft loan. Only here, the onus is switched to the recipient spouse to show that there will be repayment. That is to say, a reversal of the transaction, because it was a true loan, not a gift. Again, as always, the burden of proof lies on the party seeking to show that what they have is not what they should be deemed to have. On the soft versus hard loan issue, you may be familiar with the following guidance gleaned from the judgment of Judge Hess in last year's case of PVQ, where he analysed the authorities as essentially as follows. For an advance of money to be a gift, there must be evidence of an intention to give, animus donandi. If there is no such finding, transactions are loans. So one could say this is similar to the presumption of resulting trust. In the family court, that is not an end of the matter, because the inclusion or exclusion of a technically enforceable debt on the ES2 depends on its hardness or softness, as it is said. There is no one test as to the repayment obligation, whether it's to be regarded as hard or soft, but the question is posed, is it probable that repayment will be enforced? Or, on the other hand, is it probable that the creditor will waive the obligation, wholly or in part? And it is for the court to determine whether the case falls on one side or the other, testing the evidence against the usual factors, such as does the obligation have the feel of a normal commercial arrangement, or is there a written demand? Would there be debt recovery proceedings? Or, on the other hand, is it a debt to a friend or family member and unlikely to want the debtor to suffer hardship? Has there been a delay in enforcement, etc., etc.? Judge Hess comments on all of these different situations. So, as a postscript, one can see in this analysis the familiar workings of that ancient legal principle that possession is 9 points of the law. Proving that resources will be made available, you will receive a gift, is tricky. proving that resources have not been made available, that you've not received a gift, is equally tricky. Thank you. Now, I think I said at the outset that there's an icon at the top of the Zoom screen, and if you were to type any questions there, let's see if I can access the chat box. If nothing immediately occurs to you, and a question does occur later, please don't hesitate to email me. My email address is there on the final slide, and I'll get back to you as soon as I can. Just in case anybody feels impelled to ask a question, I shall hang on a little while. No, I've baffled you. Okay. Okay, as I say, any questions, please email me. And that concludes the webinar. Thank you for listening and attending and paying attention, if you have been. And that's the end of this transmission. It'll be online